In 1917, the people were drafted into the First World War. President Woodrow Wilson had to find a way to persuade the people to go along with an intervention in another of Europe's wars. Although restrained to be neutral in the deadly conflict by the Neutrality Act, Wilson sent the Navy to shepherd British convoys across the Atlantic. German U-boat commanders did not take the bait and avoided contact with the U.S. destroyers. To force the issue, a U.S. naval ship deliberately sailed into the midst of a battle between British and German naval fleets and was sunk. But when the truth was learned, Wilson had to find another way. The Lusitania was a speedy former warship that had been redecorated by the British and was now being used as a cruise ship passenger liner. However, unknown to its passengers, the Lusitania was carrying a huge cargo of military equipment and munitions, which was a violation of the U.S. Neutrality Act. The Germans knew this situation about the Lusitania and tried to warn the passengers of the Lusitania by placing advertisements in prominent U.S. newspapers. But the U.S. State Department ordered all of the newspapers to refuse the ad. Only one newspaper in Des Moines, Iowa, bravely published the information. To ensure a successful provocation, the Lusitania was ordered to sail at 75% speed, using only 3 of its 4 powerful engines. Then the naval escort was ordered away, leaving the Lusitania vulnerable as it entered the war zone. The first torpedo hit the explosive cargo and blew the bottom out of the Lusitania. It sank in only 18 minutes. 126 innocent civilians died. U.S. Corporation President Woodrow Wilson now had his provocation to rally people, ignorant of the true facts, behind the war to end all wars, World War II. The U.S. participation in World War I exacerbated the national debt so that it became impossible for us to pay it off in 1929. Wasn't that a nice coincidence? It also enhanced the War Powers Act that the illegitimate president, Mr. Abraham Lincoln, by executive order as Commander-in-Chief, put in place during his presidency. This War Powers Act was reinforced, and the Trading with the Enemy Act of 1917 was passed to define, regulate, and punish those who were trading with enemies, and were then required by that act to be licensed by the government to do business, any business. In 1929, the stock market crash kicked off the Great Depression, which moved billions of dollars from the people to the banks. This also removed cash from circulation for the people's use. Those who still possessed any cash invested in high-interest yielding treasury bonds driven higher by increased demand. As a result, even more cash was removed from circulation in the general public for private use to the point where there was not enough cash left in circulation to buy the goods being produced, even for the necessities of life. Production came to a halt as excess inventory overwhelmed the market. There were more products on the market than there was cash to buy them. Prices plummeted and industries plunged into bankruptcy, throwing millions of people out of work. Foreclosures on homes, factories, businesses, and farms rose to the highest level in history under the so-called new military social construct of the United States. A mere dime was literally salvation to many families now living on the street. Millions of people lost everything they had, keeping only the clothes on their backs. In Europe, the international bankers in 1930 declared social compact nations bankrupt, including the United States. In 1933, immediately after Franklin Delano Roosevelt took office, his first act as the illegitimate president was to publicly declare a United States bank holiday by executive order as Commander-in-Chief of the present military construct. He then issued a so-called Presidential Executive Order on March 5, 1933, that all United States citizens must turn in all their gold in return for Federal Reserve notes. This law was passed by Congress on June 5, 1933. All walks of life turned in all their gold at that time. The gold represented the hard-earned fruits of their labors. Why? Were we United States citizens? No. We were still a sovereign people until that time. We just thought that we were required to turn in all our gold. Only those people living in Washington, D.C. and the 14th Amendment citizens were so required. As sovereigns, we were not under the jurisdiction of the United States of America, which incorporated in 1871. When we turned in our gold, we just volunteered to be citizens of the jurisdiction and all their laws of the assumed 10 miles square of the City of Washington, District of Columbia, United States, and/or the United States of America, whichever you prefer to recognize as the true designation of such military social construct then or now. The people became captured by the misrepresentation of the status of the 14th Amendment as citizens. Our birth records become certificates, and thereby the title to our bodies. They were registered at the Department of Commercial within their Bureau of Census. This title to our bodies, all of our property, and all of our future labor, was pledged to the international bankers as security for the alleged money owed in bankruptcy by the original signatories to the social compact known as the several states of the Union, the United States of America. This was done under the authority of commercial law, Babylonian law, by and through the beneficial use of title and/or evidence of title. The people were not in bankruptcy. Only the corporate United States was in bankruptcy, which had taken upon itself the debts of the prior social compact for certain power, privileges, and immunities. But with the U.S. corporation holding the title, by and through the transfer of ownership via the definition of fungible goods to your body and life, you are now used for collateral to secure their national debt through birth certificates, given by parents ignorantly and voluntarily through condition of mind and misrepresentations of registered agents, to be entered into the commercial registry and pledged to the wants and needs of the military social construct's duty to service the debt owed by others at your expense. This act in commerce gave title to your body by way of a constructive contract, but fraud vitiates all contracts. You may still exercise your unalienable birthrights, and assumed among the powers of earth, for your separate and equal station to which the laws of nature and nature's creator entitle you. Next, the government created an artificial person with your given property name, a corporation, a fictitious entity to take its place in a virtual reality of contract law and corporations. By and through an adhesion contract via a newborn identification form with an attached identitag number for commercial registration purposes, the government then made you, the real man or woman, responsible for that fictional entity, a fiduciary and surety for an artificial entity. Your artificial entity secured the national debt by and through your future performance of labor in exchange for the beneficial interest units, Federal Reserve notes, which would arise from the beneficial use of the notes issued to you in exchange for your labor performed. This scheme allowed the military social construct to service the debt obligations of the military regime, and through it you became a 14th Amendment citizen of the United States with the bonded, by United States bonds, right to vote once registered. Then, when you became of legal age of contractual consent, you perfected the bonds by binding yourself to that status by registering to vote and giving general power of attorney to those elected to perform every act and deed in your stead as if physically present yourself. In other words, they got you to think and act as though you really were that fictional entity for all intents and purposes, as the fiduciary surety. You agreed by your action or failure to act. You adhered to a contract offer because you thought or acted as though you were the receiver of the offer. In doing so, you were presumed to have accepted the contract by general acquiescence to all the terms and conditions of the status of surety for the fiction created by the military social construct once you had perfected the bond by binding yourself by becoming a registered voter. All licenses and all existing contracts are made between the United States or the state of, whatever state of condition you live in, and your artificial entity. That fictitious entity binds you to the United States and its subcorporations because they have, through adhesion contracts as stated, made you, the real man or woman, fiduciary and responsible for that artificial entity. Of course, you voluntarily sign and even request all those contracts. It seems to be your name, although you probably never spell it all in capital letters as they do. They wish for you to think nothing of the derivatives, variations, or aberrations, perhaps just something they do to be clear and error-free, respective to positive identification as most wrongfully think. All of these contracts you sign carry with it your agreement to obey and uphold all the military executive orders, laws, rules, and regulations passed by the so-called President, Commander-in-Chief, the Congress of the United States Corporation, and the state of Florida, Georgia, California, all of them. They will be enforced against you until you decide to assume among the powers of earth to which the laws of nature and nature's creator entitle you, instead of the laws of man to which you have no underlying nexus via social compact with such agencies of government of whatever construct to protect your birthrights to life, liberty, and the pursuit of happiness. From that day forward, we the people, once upon a time sovereigns who created government for our convenience and welfare, could never own property in Elodium because the new state of the No Union now had possession of it all. In 1964, the state obtained title to all private property. You can only rent homes that you believe you own by paying taxes. You only have a certificate of title to the car you think you own, and you continue to drive it because of your yearly fee of registration is assumed to be paid. The state owns the true title to our homes, our cars, to everything we thought or think we own. You married the state through your voter's registration card, marriage license therefore allowing your children to become wards of the state, and by registering your children via the birth certificate, whereby the commercial vehicle was created for commerce as property of the state. All of this was pledged, including all the fruits of your future labor, to the bankers as security against the so-called national debt, and was placed in the possession of the Secretary of State of each state as an agent for the trustee of the bankruptcy, the U.S. Secretary of Treasury. Not knowing the rules of the game, you went directly to slave jail. You could not pass go, and you could not collect $200. The way out of this dilemma can be very complex. In fact, its complexity was intentional. Roosevelt had violated the law by placing all people into involuntary servitude without their true and informed consent. Congressman Louis T. McFadden brought formal charges against the Federal Reserve and the Secretary of the Treasury and was coming dangerously close to calling for impeachment of Franklin D. Roosevelt. 2 months after the executive order, on June 5, 1933, the Senate and House of Representatives, 73rd Congress, first session at 4:30 p.m., approved House Joint Resolution 192, Joint Resolution to suspend the gold standard and abrogate the gold clause, Joint Resolution to assure uniform value to the coins and currencies of the United States. This is the act which formally declared the bankruptcy of the United States. FDR, by executive order as the Commander-in-Chief of the military social construct, declared all people outside the militarily federalized territories to be the enemy by illegally altering the Trading with the Enemy Act of 1861, revised 1918. The creation of federal zone citizenship was strengthened when you were told to apply for a Social Security number after 1935. The so-called benefits offered by this contract were hurriedly and voluntarily entered into when the Social Security Act was signed into law because, once again, the true facts regarding the outcome of accepting such benefits were withheld due to misrepresentation and the lack of full disclosure. Further, contracts were to be entered into and licenses to be applied for all voluntary actions. We, unknowingly, were entering into lifelong servitude to receive the benefits of the Lord of the Manor, the so-called Military Social Construct Act, for and under the order of the Money Kings and the Crown of England, as the exchequer of the Vatican Treasury. We had descended, without our knowledge, into feudal vassalage not seen since before the 1512 signing of the Magna Charta. The so-called president, Mr. Franklin Delano Roosevelt, then called all the governors into Washington, D.C. for a conference. This was the beginning of the states losing the remainder of any semblance of their former sovereignty. It was not until 1944 that the corporate states lost all of their power over the corporate United States with the Buck Act. With this act, the states became, essentially, 14th Amendment citizens as well. This Buck Act completed the destruction of the corporate states having any power to protect themselves against usurpation by the military social construct known as the United States government. The corporate states now fell under the jurisdiction of Washington, D.C., as mere supervised units under the so-called federal system. Strangely enough, on October 28, 1977, H.J.R. 192 was quietly repealed by Public Law 95-147. 91 Stat. 1227. The joint resolution called the Joint Resolution to Assure Uniform Value to the Coins and Currencies of the United States was approved on June 5, 1933, as 31 U.S.C. 463, and shall not apply to obligations issued on or after the date of enactment of this section. The reason for the repeal of H.J.R. 192 is somewhat obscure. After 44 years of unchallenged implementation, this public policy was clearly established by custom, usage, and participation in the credit system by the so-called American public. Those of us operating on the privilege of limited liability via the public credit are still bound unless such liability is discharged back to the original source of the debt generated by the issuance of money of account under the copyrighted military script known as Federal Reserve Notes. The adoption of the Uniform Commercial Code, UCC, by all entities allowed them to use the designated copyrighted name of each and every state in 1964, along with a number of other like laws and acts, were incorporated within the military social construct of the sub-multi-jurisdictional franchised venues in the military social construct known as the United States. This made the Uniform Commercial Code, UCCC, the supreme law of the land appertaining to secured transactions and even documents of title, though the UCC speaks in hidden terms concerning documents of title. Under the social contract known as the Constitution, based on common law, common between those signatory, their posterity, and their agents of trust, profit, and honor, the Republican form of government of the continental United States provides for legal cases at law, in equity, and in admiralty. Law is the collective organization of the individual right to lawful defense as it operates over the creators of such social compact. It is the will of the majority, which created such compact, the organization of the natural right of lawful defense. It is the substitution of a common force for individual forces, in a reality where such individual power is limited by unity, to do only what the individual forces have a natural and lawful right to do, but in harmony with each member of the whole, to secure the benefits of the one and at the same time for all signatory thereto, to protect themselves, their posterity, their liberties and properties, to maintain the right of each, and to cause justice to reign over all willing to declare to each such pledge as necessary to accept and carry out the obligations of such compact. Since people, singularly, cannot lawfully use force against any people's liberty or property of another people, in most cases due to circumstances naturally lacking any contractual foundational societal nexus, the common force, for the same reason, cannot lawfully be used to destroy the people, liberty, or property of any people or groups of peoples. Law allows you to do anything you want to, as long as you don't infringe upon the life, liberty, or property of anyone else. Law does not compel performance with a remedy for breach of the international public order, whether locally or otherwise. Today's so-called laws, ordinances, statutes, acts, regulations, orders, precepts, are often erroneously perceived as law. But just because something is called a law does not necessarily make it law. There is a difference between legal and lawful. Anything government does is assumed legal, but it may not be expressly lawful. Equity is the jurisdiction of compelled performance for any contract to which you are a party, and is based on what is fair in a particular situation. The term equity denotes the spirit and habit of fairness, justness, and right dealing which would regulate the intercourse of men with men, connected by agreement and obligations to perform accordingly, as governed amongst those who are signatory or otherwise by such general acquiescence among them, until such time as circumstances may arise to separate the bands which either united them, or otherwise which have led them to accept such circumstances for whatever reason. You have no rights other than what is specified in your contract, which is governed by the foundational social compact. Equity has no criminal aspects to it. Admiralty is compelled performance plus a criminal penalty, a civil contract with a criminal penalty outside of any social compact, guaranteeing any privileges or immunities from such application of admiralty jurisdiction. By 1938, the gradual procedural merger between law and equity actions, the same so-called courts had jurisdiction over legal, equitable, and admiralty matters, was recognized and accepted. The military social construct was bankrupt. It now was owned by its creditors, the international bankers who controlled everything, the Congress, the executive, the courts, all the states and their legislatures and executives, all the land and all people through misrepresentation and an absolute fraud perpetrated from condition of mind. This was brought about by those exercising an unjust persuasion over all walks of life, not only locally, but upon a planetary scale as well. Everything was mortgaged in support of the so-called national debt. They had gone from being sovereigns over government to subjects under government, through the use of negotiable instruments to discharge people's debts with limited liability, instead of paying people's debts at common law with gold or silver coin according to the original mandate of the now non-existent Constitution of the Social Compact, formerly known as the United States of America. A change in their system of law from public law to private commercial law was recognized by the Supreme Court of the United States in the Erie Railroad v. Tompkins case of 1938. In the same year, the procedures of law were officially blended with the procedures of equity. Prior to 1938, all U.S. Supreme Court decisions were based upon public law or that system of law that was allegedly controlled by the social compact's constitutional limitation. Since 1938, all U.S. Supreme Court decisions are based upon what is termed public policy. Public policy concerns commercial transactions made under the Negotiable Instruments Law, which is a branch of the international law merchant. This has been codified into what is now known as the Uniform Commercial Code. This system of law was made uniform throughout the 50 franchise substates by the cunning of the military social construct of the United States in Congress assembled. In offering grants of negotiable paper, Federal Reserve notes, which the military Congress gave to the 50 substates of the former Union for education, highways, health, and other purposes, Congress bound all the former states of the Union into a commercial agreement with the federal military United States as distinguished from the continental United States. The 50 states accepted the benefits offered by the federal military United States as the consideration of a commercial agreement between the federal United States and each of the corporate states. The corporate states were then obligated to obey the Congress of the federal United States. They became supervised units of the military federal system and had to assume their portion of the equitable debts of the federal United States to the international banking houses for the credit loaned. The credit which each sub-state received, in the form of federal block grants, was predicated upon equitable paper. This system of negotiable paper binds all corporate entities of government together in a vast system of commercial agreements, has altered their court system from one under the common law to a legislative Article I court or tribunal system of commercial law. Those people brought before this court are held to the letter of every statute of government on the federal, state, county, or municipal levels, unless they have exercised the remedy provided for them within that system of commercial law, whereby, when forced to use a so-called benefit offered or available to them from the so-called government, they may reserve their former right, under the common law guarantee of same, to not be bound by any contract or commercial agreement that they did not enter knowingly, voluntarily, and intentionally. But once this has been done according to international public order, such people are obliged to subject themselves to their former state if they do not emerge into any other political status freely determined by a people, according to the same international public order, constituting modes of implementing the right of self-determination by these peoples into such a social compact for their safety, liberty, and the pursuit of their happiness. In 1976, the military social constructs United States in Congress assembled took away any semblance of law or justice left within their court system. All law today is now construed, constructed, and made up by the judge as it happens before your very eyes. Common law has almost disappeared from the courts. They took away any control or authority anyone whosoever might or could have had over the court system. This has been well hidden from all walks of life. Many of the people entering into such courts often wonder why and how the courts can simply override the laws that are paraded before them as extant and used by them in their paperwork to seek remedy to state a just claim of action for governmental abuse. It's very simple now that we know how they do it. They operate on the words construe and construct with unrestricted liberty per Senate Bill 94-201 and 94-381. A simple word such as in changed to at, as in at law or in law, has a totally separate meaning. For example, if you are in the river, you are wet, you can swim, etc. But if you are at the river, you might enjoy a refreshing picnic, play baseball, or run races. See the difference a simple word can make? The attorneys often change this word when they answer your motions in addition to many others to direct the crossing over of their duty at law in atonement owed to the chamberlains of the Exchequer of the Treasury of the Vatican. It will pay you in dividends to read the answers of attorneys to your so-called paperwork. Compare what they say the case law says to the actual case law itself. You'll discover that they have actually changed the words therein. You might say this would appear to be unlawful. No, not according to the U.S. Code. As you see, they can now construe and construct any law or statute to mean whatever they decide it means for their benefit. You don't know any of this. You think they are railroading you in a kangaroo court. No, they are legal in what they do. They usually follow the law to the letter. Their law, private law, the law of contract, which you know nothing about. This law is called contract law.